This right here is where things get real. Antonio admits to snapping someone's headphones, but what's striking is how he calmly acknowledges it, almost as if it were a minor mistake. But legally, it's not small at all. Damaging someone's property over $200 crosses into criminal territory. And when he adds that he struggled with officers, that confirms the resisting charge. Notice the judge's measured tone. She's drawing out each admission carefully to ensure there's no confusion or grounds for appeal later. It's controlled, methodical, and fascinating to watch unfold. Quick question for you. Do you think the judge is being too lenient here or fair considering the circumstances?
What we're doing?
Yes, Your Honor.
Your Honor, the defendant was pleading guilty to count 3 as charged, as well as adding count 4.
Well, the form doesn't, that's what I'm trying to figure out,
Okay.
because it doesn't say that, but it says the count 4, but not count 3.
Where would I add that?
Anywhere would have been better than nowhere.
You could handwrite that the defendant would also be pleading.
Well, yes, I'll be more than happy
Yes.
to do your job.
I'm rusty, Your Honor. I'm not here.
All right, it's the court's understanding that the plea agreement form that the defendant is going to be pleading to guilty to the stated count 3 of malicious destruction of personal property, 200 to 1,000, the 1-year offense, and also an added count 4 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to those charges, counts 1 and 2 would be dismissed. And there is a consent by the prosecutor to HIDA. That is the court's full understanding of it.
Yes, Your Honor. Yes, Your Honor. That is the agreement that I have discussed with my client. He would like to accept that offer today.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Antonio Cornelius.
Stated his name. I'm sorry. All right. Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
No.
Is that your understanding, Mr. Cornelius?
Yes.
Sir, do you want to enter these pleas?
Yes.
Are you going to answer my questions then?
Yes.
You understand that you'll be pleading guilty to 2 misdemeanor charges?
Yes. Your Honor.
Counsel, approach, please. Record should reflect that we've got a bench conference in the Cornelius matter. I'm going to pass the matter briefly, let him have a conversation with counsel, and then let us know when you're ready and call you back up.
Thank you, Your Honor.
Court does recall the case, People versus Antonio Cornelius.
Zachary Wood on behalf of the people.
Wow. Was that a sneeze or just a scream? That hurt my ears.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius. He stands to my right. Please state your name for the record, sir.
Antonio Cornelius.
All right, and I have had him sworn. And so we were in the middle of a plea, and sir, my understanding is that you wanted to take advantage of this plea offer, is that correct?
Yes, Your Honor.
All right. And you understand that you will be pleading guilty to 2 misdemeanors?
Yes.
All right. First of all, this court's understanding that you'll be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Also, that you'd be pleading guilty to an added count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Now, understanding all of that, you still wish to plead guilty to these charges?
Yes.
All right. To the charge of malicious destruction of personal property, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights for today, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not at this time.
Has anybody promised you anything other than what's been stated here today to get you to plead to these charges?
No.
Anybody threaten you or coerce you in any way?
No. No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of these offenses?
Yes, Your Honor.
On the date of March 5th, 2025, at the location of 2281 Bonesteel Boulevard, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do regarding the personal property of a Jonathan West?
Broke someone's headphones without permission.
Pardon?
Broke somebody's headphones without permission.
Okay, so you got their headphones and when you say you broke them, what did you do?
Attempted to snap them in half.
Say again?
Attempted to break them.
Just break them?
Yeah.
All right. And you didn't have their permission to do that?
I did not have permission to do that.
All right. And you didn't have any property interest in these headphones, meaning you didn't own them at all, did you?
No intent of theft.
Pardon?
No intent of theft.
He asked if you owned them. Were they headphones?
Did not own the headphones.
Okay. And these headphones, are you disputing that they had a value in excess of $200?
Yes.
You are disputing that?
No.
Okay, so that, maybe I asked the question badly.
I'm not disputing.
You're not disputing that they were worth more than $200,
Yes.
right? Okay, I just wanted to make sure. At some point, then, did you come into contact with officers from the Ann Arbor Police Department?
Yes, said they were from the Ann Arbor Police Department. They may have had DPSS caps on.
Your Honor, they were using,
It was U of M.
Yes.
Oh.
Yes, Your Honor.
So you came into contact with officers from University of Michigan Department of Public Safety.
Yes.
And what happened in regard to your interaction with them?
They grabbed my arm. I struggled after they grabbed my arm.
You struggled with them. They were grabbing your arm to arrest you?
And there it is. The judge accepts Antonio's plea to 2 misdemeanor charges, dismisses the other counts, and schedules sentencing for June 3rd. For those unfamiliar, this kind of plea often comes with reduced jail time in exchange for accountability and cooperation. Antonio's honesty, though hesitant, likely worked in his favor. But this case reminds us, even small acts like damaging property or resisting arrest can carry serious legal weight. What do you think? Should he face jail time or just probation? Drop your thoughts below. And if you found this breakdown insightful, don't forget to like, share, and subscribe for more real courtroom analysis and dramatic legal moments every week.
Yes.
And you struggled with them either to make the arrest of you more difficult or to try to stop the arrest itself or to at least do something to obstruct what they were trying to do.
Yes.
Is that correct?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's pleas, 2 counts, 3 and 4.
Welcome back to the courtroom, where confusion turns to clarity, and a simple plea deal spirals into a surprisingly tense exchange. Today, we're following the case of People versus Antonio Cornelius, a man accused of damaging property and resisting arrest. But what starts as a routine hearing quickly takes an unexpected turn. Will Antonio's calm demeanor hold, or will his silence and hesitation push the judge's patience to the limit? Let's dive into this dramatic courtroom moment that's got everyone talking. Welcome back to the courtroom, And buckle up, because this one's about to spiral into chaos. Today, we meet Joshua William Wara, a self-proclaimed jailhouse lawyer who refuses any legal counsel and believes he's the target of an Illuminati-led conspiracy. What starts as a simple traffic case quickly descends into wild claims of trillion-dollar thefts, secret government plots, and accusations that even involve Elon Musk and Donald Trump. The judge tries to keep things on track, but Wara's explosive allegations turn this courtroom into pure confusion. Stick around, because this hearing tests patience, sanity, and the very limits of courtroom order.
Sophia Simpson came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati.
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited to
Thank
do
you,
so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolph Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay,
They're
but
the
I've got to
Ku
do
Klux
something. I've got
Klans.
to do something. I've got to
With
do
the
something with your
NDOC.
case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10 times the
they-
amount of what was stolen from me. They stole $666.8 million from me. They then turned it into 5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can
Okay.
criminally prosecute to the fullest
I'm with you.
extent, which is
I'm
my
with you.
right.
I did that. I did the math too. Listen, here's the thing.
Mhm.
I have to advise you, because if you are going to represent yourself, what you're here on,
I'm doing
okay?
it over Zoom. 'cause they're
So
trying
you're
to kill
here
me.
on a complaint that alleges that on October 15, 2025 on South Main Street
The Pentagon's
in the
using
city of
prism
Ann
to make
Arbor,
the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount, because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount, but since it is conspiracy
Okay.
to murder, sovereign law
I'm with
does
you.
not
I
exist.
got you. I just have to let you know what you're
Which
charged
means
with.
I can sue for
There's
1,000
also a
times the
count
amount.
2 on the complaint that
Legally.
alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay, so there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of, that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Cedric Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No, I do
then all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen-
trial,
listen
not
to
a
what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
backed
any point
on
you
objective
do,
evidence.
if
A
at
bench
any
trial
point
is
you
objective
do
evidence.
want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I
Now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial
that's
can
not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law and it's conspiracy to murder, and Donald Trump and Elon Musk are involved, and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if
not
I can
exist
if I
because the
can-
amount of money that
I
they
don't know,
put
I've
that
not
hit
been
out
very
on
good at
me,
it, but.
and Donald Trump and Elon
Oh,
Musk and Adolph
so-
Mack and Doug Minkoff and Jeffrey Peak and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get.
Okay, okay, I'm with you. I got you. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has one. So we would need more time. The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do. Sir,
Frederick Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't, yeah.
Okay, but you
There
haven't
are too
seen
many
the
people involved.
You
have a
haven't
Neuralink
seen.
in your brain.
Okay, pause for a second. Did you catch that? Joshua just accused the judge of having a Neuralink implant and being part of a Nazi conspiracy. This is beyond courtroom chaos. It's a meltdown in real time. You can feel the tension shift as the judge stays calm, patient, and surprisingly composed, despite the outbursts. And this raises a huge question. Should judges keep cases like this going, or call for a mental health evaluation on the spot? Because at this point, the defendant's delusions might be overshadowing the legal process entirely. What do you think? Is the judge being too patient here?
And you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
And based on
listen.
factual evidence, the jury
No,
trial can be tried.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please. With all evidence, I would like to.
You want to
subpoena
represent
all records
yourself.
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Juarez.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolf Mack, Donald
We're not
Trump,
bringing out those people
Elon
down.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm gonna indicate he doesn't want his discovery. Says he doesn't need it. Would they, man? I'm not gonna have the complaint that's rights have been infringed, so yes, I'm gonna do it. And you're gonna be mad. It's okay.
You don't care about my feelings.
I don't care about your feelings because you don't care about mine. But we shouldn't air this in public. No, I have to do the, no, I can't. I cannot. So I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm gonna do. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm gonna
Yes.
give you your preliminary examination. So your preliminary examination will be set in person on,
Your Honor, I'm so used to just
And,
saying, yes, sir.
Adolf
no, I
Hitler
know,
is in
but
the
I
judicial
realize it's
court
close, but
with Carol Conkey and East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She was at 22nd Judicial Circuit Court with Feiger and Ellen Warren and Jeffrey Peak. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolph Mack. I'm giving him the electric chair. And I'm suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolph Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm going to do.
And Donald Trump.
I don't know that we'll be able to go given how you're
Yes,
acting.
we will.
but
I want
I'm
a
gonna
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolph Mack, JP Morgan.
I'm going to set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. You know, I'm not, if I let the PD off, because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr.
And there it is. The judge finally hints at what many of us have been thinking all along. A possible competency evaluation. That means the court will assess whether Joshua even understands the nature of the charges or can participate in his own defense. It's a crucial safeguard in any fair trial. Because if a defendant isn't mentally fit, the system has to pause justice until they are. From conspiracy theories to courtroom patience, this case had it all. If you found this hearing as unbelievable as we did, make sure to hit that like button, share your thoughts below, and subscribe for more shocking real-life courtroom moments and expert legal breakdowns. Until next time, stay sharp, stay curious, and stay tuned for more courtroom chaos. Welcome back to the courtroom, where tension meets truth and justice unfolds in real time. Today's docket is packed with drama. From a defendant accused of posting explicit photos online, to another pleading for leniency while juggling school, kids, and court dates. But as the judge digs deeper, shocking details emerge about intimidation, probation, and hidden violations. Buckle up. This hearing is about to expose who's really playing by the rules, and who's playing with fire.
AKA the phone.
Again, Your Honor, I apologize. Someone dared call my work cell.
What? Somebody called your work cell? I think it was somebody over there. They just, all right. Okay, what are we doing? Your name, sir?
Jeff Murphy.
Thank you. What are we doing?
Your Honor, discovery is complete in this matter, requesting an exam be held.
No. People have their witnesses available the 27th?
Your Honor, if I may have a moment.
Yes.
Your Honor, I do want to bring up something else that's concerning this case, and at this point, I'm hoping that the court can warn the defendant. I'm sure Mr. Burgess will speak to him as well. Part of this case is defendant posting naked pictures of the victim. Not that they should be anywhere, but certainly places that have put her at risk. They have since been taken down, is my understanding. So if the court wouldn't mind issuing a warning to the defendant about ensuring that does not happen again. And I believe Mr. Burgess is well aware of what I would do if this happens again, so he can have a conversation with his client about.
All right. So these came up after the charges in this case?
Let me double check. Your Honor, we don't know the exact date. I have to look into that.
Okay, but they have since been taken down.
Yes, it's been taken down, which is why I'm asking for a warning as opposed to.
All right. You understand that, sir?
Yeah, yes.
All right. And Mr. Burgess, you're gonna have a more detailed conversation with him about that?
Yeah, yes, I will, Your Honor. I'm well aware of what Ms. Tanner will do if that's the case. If he does it again, if it happens again, if it did happen in the first place, Your Honor. So,
All right, very good. Okay. And with the people
That's a good date, Your Honor.
that will work,
thank you, Your Honor.
preliminary examination in person, May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you. Let's call the case of the people versus Frank Clark.
Okay, I'm sorry, Your Honor. I apologize. You recall that previous case. Apparently I wasn't clear,
Okay,
if you don't mind.
you weren't clear? Okay. I guess, can we get him back?
If the defendant feels it's appropriate.
Well, hold on a second, because I lost Mr. Burgess.
I can call you on it.
Okay, so when he appears, we'll get him back out at some point.
I'm in the court. I'm in the court.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender for Mr. Clark, who's in the court.
Yeah. Thank you, Mr. Clark. Court recalls case, people versus Jeffrey Murphy.
Franklin has assistant prosecuting attorney about people.
Good morning, Your Honor. Again, may it please the Honorable Court, David Burgess on behalf of Jeffrey Murphy.
All righty. Thank you for coming back, Mr. Burgess.
Yeah, of course,
Yes.
Your Honor.
Thank you, Your Honor, for recalling the case, and thank you to Mr. Burgess for jumping back on. Mainly, I want to make sure the defendant's not confused about how this process is going to work and what his bond conditions are. The victim was present here today in the gallery, and defendant decided it was a good idea to mean mug her as he walked by her. Here.
Sir.
Now, I know that this defendant has a history of abusing women sexually and physically, and apparently somewhere along the way, he has learned and decided that intimidating a victim of his crime is a good idea. Like I said, I think he's confused, so if we can clear some of that confusion, I would appreciate it.
All right. So you.
Whoa, things just took a dark turn. The defense attorney's casual tone disappears as the prosecutor accuses the defendant of mugging or intimidating the victim right inside the courtroom. For context, that's not just bad behavior. It's a potential contempt of court issue, and could lead to new charges for intimidation or harassment. Judges take this very seriously, especially in cases with prior allegations of abuse. The courtroom is supposed to be neutral ground, but moments like this remind us how emotions can override judgment. If you were the judge, what punishment would you hand down for this kind of courtroom stunt?
Understand that? That you're not, and when the court is saying no contact, no intimidating or threatening behavior, that applies both here in this courtroom and all of your behavior. You understand that, sir?
Yes.
And so if the alleged victim is present in the courtroom, I don't want you staring at them any kind of way.
I got you. I apologize.
All right? All right. Thank you. Thank you, Mr. Burke.
Yes, of course, Your Honor.
Sir, oh, 2 in a row.
Kevin Addition on behalf of Mr. Serval, who is asserting.
Your name, sir?
Romeo Serval.
Thank you.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond, please.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. I need a green sheet and then that's bond.
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Servo is 20 years old. He has 2 children that he takes sole custody of. He has He has to take care of them right now. They're in the care of his father and his foster grandfather and foster grandmother who aren't able to actually keep taking care of his children. He has been in school. He has a 4.0 GPA. He just got his transcript back. He had a job interview. He's doing really well. The reason he was missing them is just because he had so many things going on. They were early in the morning. He has these 2 kids. I can assure you that if you put him on a tether, Your Honor, that you will be seeing obviously no missed tests, but no positives or anything like that. He is not drinking. He doesn't drink. He reacts very poorly to it. So we are going to be asking for that.
Yeah, but he wasn't testing on his SoberLink device. I mean, he just wasn't testing like he should.
Yeah, there's 2 that he missed. He was in custody for those. Those are the first 2 missed ones on the report from March. And then he had 4 missed ones, but he submitted a compliant test like within 15 minutes.
I'm talking about, I got that, but his April 24th report from Community Corrections.
I'm not in receipt of that. The last one I have is as of April 23rd. I may have missed it, but
April.
The report that I have, the last test on there that was missed was the 23rd of April. Let me look.
Right, but there should be a bond violation report from that's dated April 24th, 2025.
Oh, this is the one. Oh, no, sorry. Yeah, April 24th. This is the same one I'm looking at.
Okay.
Okay.
Go ahead.
Yes. Again, as 2 of those were missed when he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after the 9 a.m. block. I believe there's only 2 that he missed that he never retested for, and those were the newly added time window. I believe he had either forgotten about those, and I understand that that's not an excuse. He just has a lot going on with school, with work, with his 2 kids, and that's why I believe having him on a tether would resolve this issue. He should have been put on tether from the beginning, honestly. But if Your Honor releases him on that tether, and he's not missing any of his drug tests. So,
any response? Okay.
The only thing I'm concerned about was in September of 2023, the defendant was placed on probation in the Oakland County Circuit Court on 2 counts of RIO and an A and B or HIDA. And obviously this offense occurred in June of 2024. So it would have been while he's on court supervision at Oakland County Circuit Court on a similar charge that also qualified the defendant's ability to cover.
Your Honor, he is undergoing mitigation for mental health concerns that we're going to provide to prosecution. I've talked to his attorney in his Oakland County cases. He is on probation for those. He's testing in so many different places for so many different things. That's why also he is having trouble keeping track of these tests. And I mean, again, I believe a tether would help with all, huh? What do you want to say?
I just want to tell him that I did ask when I realized it was going to be a problem. So I won't have any problems with it.
Yeah. He's saying that he requested, he wanted a tether in the first place. And
when you're saying a tether, you're talking a scram tether?
Yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't hear it from me. I don't drink alcohol. There's no alcohol in my household. It's just 2 children and I go to school every day.
2 children and some pot, right?
Well, I smoke outside the house and it's never around them.
Okay. Do you have a card?
Yeah, I do. And
did you give us your card?
I offered to give that to community corrections, but they refused to take it every time I offered it to them.
And his father submitted it. They'd already submitted it to community corrections. I don't know why community corrections lost track of it, but I talked to his father yesterday, and his father said that he sent community corrections a copy of it again yesterday, but that every time he goes to test, he has his medical marijuana card on him and it's active. And I can send that to the court right now.
Yes, I will.
And there you have it. 2 cases, 2 defendants, and 2 very different paths through the justice system. One walked away with a warning and a strict no-contact order, while the other faced probation concerns and left the courtroom with a tether requirement. These hearings show how fragile second chances can be. One misstep, one missed test, and freedom can vanish instantly. So, what's your take? Are these rulings fair or too forgiving? Let us know your thoughts below. And if you found this breakdown as eye-opening as we did, don't forget to like, share, and subscribe for more shocking courtroom moments and legal deep dives every week. Welcome back to the courtroom, where justice meets real life and excuses meet reality. Today's case, People versus Jane Martin. What starts as a simple probation hearing quickly spirals into an emotional backstory of loss, struggle, and responsibility. Jane, a single mother of 5, stands accused of failing her probation terms. No payments, no classes, no check-ins. But there's more to this story than meets the eye. Was it neglect or survival? Let's dive in and see how this courtroom handles compassion versus consequence.
Ms. Martin, please state your name again. Johnny Martin.
Chris Blair on behalf of probation. Your Honor, Ms. Martin is before the court for a violation of probation hearing. Ms. Martin has been on probation for 2 years for a reduced charge of assault and battery. In this case, Your Honor, Ms. Martin has made no payments to the court. Her balance is $1,530. Probation has failed to receive completion of the CPS Family First Program and Parenting class. Ms. Martin also failed to report to probation after April of 2024. And Your Honor, her probation term is maxed in this case. Given that these items were not completed, probation is recommending that Ms. Martin serve 93 days in jail with credit for 1 day served, that she serve the balance, waive remaining terms, accept the financial obligations, and discharge her from probation.
Ms. Perry.
Your Honor, I was able to speak with Ms. Martin about these issues. She believes that she did complete the CPS and parenting class. She's been trying to get in touch with them for the last week or so to get proof of that. She has called the case manager that was on the case. She no longer works there. She gave her another number at CPS. They told her they would call her back. It's kind of she's been, thwarted by bureaucracy. So I'm asking to adjourn this hearing out a bit so she can continue working on that. Again, she remembers completing it, but it has
Why
been.
didn't that information get to probation?
Frankly, Your Honor,
I can tell you why, because she never reported to probation.
She did. That is the allegation, Your Honor. Around the time that this was all happening, the father of her 2 youngest children was killed in Washtenaw County. And I think she's a single mother. That kind of, greatly affected her life. And she's been dealing with the repercussions of that since that happened in June of 2023. So she wants to get proof to probation. She's just having trouble doing so.
What about payment? I have no payment. I have no reporting to.
This moment right here hits hard. You can hear the exhaustion in her voice. 5 kids, grief, financial pressure. It's a lot. But the judge isn't wrong either. The court can only go by what's on record. Without proof of progress, the law sees non-compliance, not hardship. It's a brutal reality many defendants face. Life's chaos doesn't excuse legal obligations. Viewers, how would you handle this? Is the court being too harsh or just doing its job?
Probation. I have nothing. I just started working out.
She has 5 children?
Yes.
5 children, 11, 8.
11, 9, 8, 3, and 1.
So she, for a long time, didn't have childcare. to care for her children and work.
I just started working. I can't make a payment when I get my check.
How come you didn't report to probation?
I don't know, like I had a, like after my child's father passed away at my apartment complex, I just shut down. It was like real hard on me.
I get all that, but I guess the last time you were before the court was in February. Like, you're gonna pay the fines and costs by March 3rd. No payments. You would report to probation. No reporting to probation. I'm assuming you were supposed to complete the Family First program and parenting classes. I don't have any proof of any of that.
As I completed it, I went to Orchard's Family, Children and Family Services. I think that's what it's called.
When?
I finished that class in 2023. I just didn't report it.
So you're saying that was completed before I sentenced you?
Yes.
Runner, I can try to look to see what the prosecutor's office may have.
What the prosecutor's office may have?
Yeah, I mean, maybe it was provided to them to reduce the charge, as this charge did originate as a child.
Anything else from anybody?
Nothing from me, Your Honor.
Do you have anything else you want to tell the court?
I was just give me some time to like make the payments. Like I'm all my kids got. Like I don't really want to go to jail. I'm already have.
Should have been keeping in track with probation.
Right.
You just didn't do anything.
I know that I did. I know I did.
Okay, so here's what I'm going to do. I'm going to waive the remaining terms except for financial obligations. I'll discharge her from probation without improvement. What I am going to order is that she's to serve 93 days in jail. I'll give her credit for the 1 day. She's to serve the balance. I will strongly consider release if I get proof of completion of that class. All right, you're still going to owe the money. You need to set something up with the court. You're going today, but if they get me.
And there it is, the final ruling. 93 days in jail with a chance for early release if she proves completion of her parenting class. The judge walks a fine line between accountability and mercy, reminding everyone that excuses don't erase obligations. This case perfectly shows how personal tragedy collides with the legal system, and how proof can make or break your freedom. If you found this case as thought-provoking as we did, make sure to like this video, share your thoughts below, and subscribe for more real courtroom breakdowns where justice and humanity meet head-on.